Everybody welcome her on stage. Joining her on panel are Sameet, Group Head Legal of UFELX Limited, India. Irith Kist, Data Protection Officer, Netherlands, Cancer Institute in the Netherlands. Pavle, Legal Manager, Abacus Legal, Netherlands. And Nico Mooduto, partner of SSEK law firm Indonesia again. Everybody welcome Nico. And Wakas Farid, founder and director of Conquest Law Solicitors UK. Please warmly welcome them. Over to you, Ms. Campos.
Hello everyone, good morning. Welcome to our panel about future of data protection laws. My name is Emilia Campos, I'm from Brazil. And in Brazil I work with cryptocurrencies and blockchain technology, and tomorrow we'll have a panel, Section 8,
Yes.
I'm not worried,
Yes.
I'm not wrong. And we'll talk about cryptocurrencies, but I can answer your question after the panel. Well, it's a real privilege to be here moderating this panel about the future of data protection laws around the world with professionals from some countries, and it's so good to have this opportunity to exchange ideas. And to be honest, data protection is not the most interesting topic for a dinner party, but in our profession, it's the star at this moment, and it's good to be part of this show of data protection. Over the last decade, data protection has gone from being a little box of compliance to tick to be something that can make or break global deals, and is something that can make CEOs and their lawyers awake at night. But in this panel, we will discuss about the legal framework around the world and the challenges that the CEOs and the lawyers are facing in this subject. At the same time, I would like to bring some Brazilian point of view about data protection, because in 5 days we have a strong legislation, our own data protection law, really based in the GDPR, but we have a very Brazilian characteristics for this law. We have a strong authority, national authority for data protection. We have frameworks for specific sectors wherein the data protection is more important. And we have very specific rules for data protection. It means that we made a lot of work in this 5 years. Then let's see what our colleagues has to share with us about their experience on data protection in their own countries. I would like to invite each panelist to make their introduction and to introduce itself, because I don't like to make any kind of mistake with the different and amazing names. Thank you very much.
Thank you. Good afternoon again, ladies and gentlemen. My name is Nico Mooduto. I'm a partner with an Indonesian law firm. My practice area is dispute resolution and commercial arbitration. The data protection space is quite a recent practice that I've taken up in recent years. And that is primarily because Indonesia, and I think Indonesia is one of those countries that is lagging behind in this space. Obviously, Europe is, with the GDPR, is at the forefront. Indonesia has just introduced its personal data protection laws in 2022. And within 2 years, the government was expected to issue implementing regulations to implement that statute. And that deadline was supposed to happen in October 2024, but lo and behold, the government did not issue its implementing regulations. So there are still gaps, if you like, on how sort of this new body of laws, as far as Indonesia is concerned, is going to be implemented. And so there will be updates in the near future on how Indonesia addresses data protection. Now, I would like to address, nevertheless, how this particular legal framework would affect how essentially how people do business in Indonesia. And I've highlighted essentially seven areas. The first one is obviously with this new law, or with this recent law, businesses, it will change how businesses conduct their business, how companies conduct their business. There will be changes, or the requirement that companies will have to appoint what is called a DPO, or a data protection officer. And it's equivalent to a compliance officer, but this is a certified data protection officer. Also, various data protection policies will have to be created or amended or renewed, whatever the case may be, so that it aligns with the requirements under the law. There's also other sort of business functions that will have to be either created or adjusted and amended as well as a result of this. For instance, the ROPA will have to be done by companies going forward. The second sort of aspect that I've highlighted is how it affects cross-border data sharing. Now, before, there's really no regulation on companies that seek to share data between countries. Now, with this this new recent law, companies are required to report cross-border data transfers. Now, the requirement is a reporting requirement, not an approval requirement. But you never know, because data is considered, or even more so, of being a very fundamental asset these days. Maybe there's interest from the government to sort of try to regulate further on this particular area. The third sort of aspect that I've highlighted how this would affect Indonesia businesses going forward is there is a policy from the government that wants to centralize data within and to the central government. So the government is expending costs to build this centralized data infrastructure. And so with that, obviously, there will be rising costs and potentially rising taxes as well. So that will be the sort of the fourth highlight of the changes that resulting from this framework. The fifth sort of aspect that I've highlighted is the rise in data center investments. There are a number of companies like Microsoft, AWS have increased their investment in data centers across the globe. Indonesia is included as well. We've seen a number of rising data center players, from hyperscalers to the more smaller ones, and there's no end in sight in those in this particular sector. You would think that at one point it becomes saturated, but the way I see it in Indonesia, it keeps on rising. So that's also another thing that I've highlighted. Now the sixth aspect that I've highlighted, which is sort of what I'm familiar with, and that touches on my area of expertise, is the rise of data breach litigation. Now previously there's not much data breach cases in Indonesia, but in the last 2 years we've seen a significant increase on that. Just in the past 6 months alone, I've received 2 mandates from clients who've been involved in data breach litigation, and potentially one will be going into arbitration, but we'll see how that develops. But the fact that there are rules in this area means that there will be potential breaches of these laws, and then litigation and suing as a result. And the final aspect that I would like to also highlight is that, interestingly enough, under Indonesian laws, and I'm not sure how it is regulated elsewhere, but under the Indonesian personal data protection law, there's a sanction for a breach of maintaining, if there's a data breach and there's an obligation under the law that is violated, the violator or the company that is involved in the data breach can be imposed with a fine of 2% of the company's annual revenue. So if you could imagine that 2% of the company's annual revenue can be taken essentially by the state. So I would expect that there may be more rigorous government actions to try to enforce the data protection laws going forward. And obviously with that may be a rise in litigation against the state as well. So let me just pause there and stop there and hand it over to back to the moderator.
And can I just shoot a question at you?
Sure.
The word is with you, but it's your time. It's not a
Round of applause for Nico.
Yeah, we'll deal with that in a second. The name's Pavle Bojkovski. It's not the easiest. I'm a sole practitioner here in Amsterdam in the Netherlands, specializing in all things IT legal. I think that Irith and I will be dealing with a very similar field of attention, and the topic that I would like to focus on for a brief chat today is a niche but a vital topic. As Nico identified properly, data transfer and cross-border data transfer is the bread and butter of a large part of the tech industry nowadays. Data transfer at the same time is a topic which, in a European perspective, is heavily regulated, but the actual practical manner of making data transfer possible is changing, and we're seeing that businesses are trying to find technological solutions in order to deal with legal challenges. Why is this so important? From a European perspective, we know that there's a pretty simple rule. You process personal data within the European Union unless, and the unless is that you may process personal data outside the European Union if you move it into a jurisdiction where you can vouch for a like level of protection as is offered to data subjects in the EU. Now, what does that mean? That means that theoretically, either the European Commission can issue a finding stating that a given jurisdiction complies with the same level of protection, or you may put in place a different mechanism allowing you to transfer personal data. And this has been a topic of discussion, this has been a topic of litigation, and some of you may be acquainted with the so-called Schrems litigation. Max Schrems was a young student who objected to the manner in which Meta or Facebook processed his personal data. He litigated their processing of his personal data once. He won. We saw new regulations arise. He still wasn't satisfied. He litigated it again. We got the Schrems 2 case. And ever since the Schrems 2 case, we've been dealing with a lot more complex world in transferring personal data outside the European Union. And the issue at hand was that the Court of Justice of the EU ruled that it wasn't enough for companies to have simple paperwork ready, providing a nominal and theoretical same level of protection as within the EU. Rather, companies had to make sure that the level of protection offered by receiving jurisdiction was actually the same. The same as I think it's that way. Yeah. Yeah, okay. Companies had to make sure that the level of protection offered was practically similar to the EU level of protection. And that is where we get into a new element of the modern data transfer practice, the data transfer impact assessment. The DTIA requires data exporters to ascertain that they can provide the same level of protection when exporting personal data. And that brings me to something that I'm looking for here today and tomorrow, namely an update on the state of data protection laws worldwide. Because why? From a European perspective, when you're exporting personal data abroad, you carry out your data transfer impact assessment. You have to discover and document the level of protection being afforded by the receiving nation. So, for instance, an important part of my practice has become analyzing and decoding, for instance, the state of Indian data protection law. Likewise, Indonesia is also a important business partner for the Dutch. And also what you're seeing is this, where you are transferring personal data out to the United States, we are getting recurring questions and recurring debates on what the actual extent of the law is and what the state of the law is. And that brings us to the major geopolitical challenges that we're dealing with now, namely that legal certainty is receding. We have spent 3 decades where we've been used to governments respecting the rule of law and actually working within legal frameworks. And we have now arrived in a time in society where we are throwing away the rule of law, and governments do not feel themselves as bound as they used to be in the past. What that boils down to is a lot of uncertainty, uncertainty in data transfers and export of personal data abroad. This means that our profession has to deal with an ever-increasing amount of data protection work, some of which is of dubious effect because it does not matter as much what the law states. Rather, we find ourselves trying to decode what governments are actually doing, and that is a challenge that a lot of European companies are responding to with a focus on data sovereignty. A topic that's going to be expanding in the future, and that is the movement basically to keep personal data, to keep data within the actual geographical confines of the European Union, and seeing how the EU has been a trendsetter in this space for the past 10 years now. You might expect to see this happening in your jurisdictions as well, where governments and where businesses are going to start looking at how they can process personal data, how they can develop IT operations within the national borders rather than relying on hyperscalers. And hyperscalers in turn are responding by developing more and more national processing programs. So it's an extremely exciting time. There are huge developments, and I really look forward to our discussion further on and hearing how other countries and other jurisdictions are developing on this. And Irith, I hope I haven't gone too much into your field.
No.
Great.
Thank you so much. My name is Irith Kist, and I'm a data protection officer at the Netherlands Cancer Institute and also at the Water Management Board in Delft. I'm going to focus on health law in particular, and of course we have shared the hurdles that we encounter in data sharing, and we have also shared together which possible solutions there might be. Working at the Netherlands Cancer Institute, working there, I see the patients each and every day, and I see that they, of course, would do everything and anything to be healthy once again. And the contradiction that we may not share here is that here, of course, each and every day we are involved in protecting the data, which is good, which is our job, which is our task to do. However, when patients enter for an investigation, health check, in an MRI scan, so often they're asking the doctor, why do you need to ask me about my health once again? Isn't it again already in the machine? So we, in my view, need to overcome the presumably all the hurdles that we're facing, because we're doing the data sharing for our patients, our mental health care, for our clients. Let's bear that in mind for one moment. In my PhD research, I focused on bridging the gap between, on one hand, the health data protection, the protection of these sensitive data, and on the other hand, also to make sure that we continue to share the data. In cancer research, it occurs that, for instance, there's one patient in Holland with a rare type of cancer, one in India, one in Brazil, one in Portugal. Throughout the world, we do need to share those data, no matter what, in order to combat the diseases. Then in European law, ever since the COVID pandemic and already before, it became evident that data sharing would become even more important each and every day, because diseases are spreading throughout the world, and we can only combat those diseases if we collaborate and cooperate together. So the European Health Data Space was one of the regulations as a result of, for instance, that COVID pandemic. And in the European Health Data Space, once and foremost, it was stated that we want to share those data as one of the economic sources. And here it becomes tricky for many of us. Here we're thinking, well, yeah, so far so good, we do want to share those data. However, how can you, as the Netherlands Cancer Institute, how can you guarantee that the data are protected? And then we recently in Europe, we had, in my view, a landmark case where the relative point of view with regard to anonymization was upheld by the European Court of Justice. And what did that case say? Why is it, in my view, that important for health law? Well, in that case, it was stated that if I, as the Netherlands Cancer Institute, if I want data, personal data of my patients to be researched, to be investigated by a partner in any other country in the world, we need to make sure that the recipient of those data cannot, will not, could not, may not, does not reveal the person behind that data. The data, once again, will need to be shared. Secondly, I loved the conversations about AI, and the recent AI Act in Europe, of course, also tries to strike the balance between the innovations and also between protecting the data. Let us turn back again to our patient who suffers from cancer or any other disease. It has already become apparent that the data investigated with the aid of AI are much more detailed than what the human eye could see. So if you have images of, for instance, of breast cancer, the doctor cannot see what AI techniques can see. So there needs to be a way, we need to build that bridge between, yes, the data that need to be, of course, investigated through the aid of AI, whilst at the same time we need to make sure that no matter what, the data could be relied upon once again by the individual. However, in healthcare and health research, you do not want a full anonymization. You do not want that. Why? Well, because there could be accidental findings that could be of importance for the patient. So I do love the law. I do it as a legal counsel, as a data protection officer. I do love the work that I do. And I always do my work with a view to the patient who suffers from cancer, who would love that that particular tiny tumor would be recognized either by the doctor, but nowadays with the aid of AI. So what we see in Europe now is that we have parallel acts. We have the GDPR, we have the European Health Data Space, we have the AI Act, and we have the Medical Device Regulation. And I see a common layer there. I see common ground between all those regulations. And all these regulations do state, be aware of the fact that when you process health data, those are sensitive data, so you need to take extra precautions. In my view, you should do that beforehand. Secondly, what you also see is that we do need the innovations in our economic hemisphere, and we do need that especially in healthcare, because another disruption is what we saw with the COVID pandemic, whilst at the same time more people during the COVID pandemic died of cancer than they died of COVID, to bear that in mind. So we need to share those data throughout the world. And yes, of course, we do have the SSEs, we do have bilateral contracts, but there needs to be an underlying field of trust from our patients into the institutions who process the data, and trust in ourselves, in the work that we do, that we will only use the data for the research that we carry out. Lastly, I think it is important that we as institutions are transparent and open about the data sharing at all times. We have a quite recent case in the Netherlands, and the ones you hear, you could not have missed it. It's about the national investigations that each and every woman in Holland is invited to participate in with regards to try and prevent in an early stage the cancer types for women. There was a major data breach in one of the labs that carried out those checkups for the women. And of course, what you do see then is that communication is extremely important, communication and transparency. If you don't do that, then the women will have lesser trust, then they will not go to the lab to have an investigation, a checkup with regards to particular parts of their body to see if they have an early stage of cancer. The trust decreases, and of course then we do see that the data will be limited. That of course the source of the data that you need to use, that you need to investigate, will be limited. And it has already been shown that with regards to who shares the data, you can see a difference between population areas in our country and in our countries. And what I would like to hope for is that we maintain trust, that we maintain confidence, and also that as the institutions that we keep the utmost transparency and clear communication about the data. That's for now, and I'm looking forward to a fruitful discussion afterwards. Thank you.
Thank you very much. Thank you, moderator. My name is Sameet Gambhir. I'm from India, New Delhi, and I work as a senior vice president with UFELX Limited. It's a company into flexible packaging with almost now offices in 10, plant in 10 countries, more than 10 countries, and now offices in various countries. So I've been in this field basically. I'm a lawyer and a company secretary, and the last 35 years in legal compliances, corporate secretarial, and all. Now in India, actually, we are gearing up for the data protection regime and data protection compliances. The reason is that we are still new in this. We are still new in the sense that we have recently come up with a law 2 years ago, and as my friend was saying that we were actually lagging behind in terms of putting around the law for the data protection. But thankfully now we have a law in India which was passed by the Parliament, and the President assent was given in 2023. 2 years has been passed, but still it is not fully implemented. The reason is that the rules are in process, and while I'm speaking here, the rules must be in the way of publishing or maybe notifying in another 2-3 days. So we are fully geared up for that. So the India regime of data protection is what I would say. We didn't have a standalone data protection law before that, but we always have an IT Act, so Information Technology Act 2000, wherein when this law was basically for the cyber security and the cyber crimes and all. This was always there. Then there was an amendment in 2008, and there was another provision which was brought in the IT Act, wherein we're talking about the data protection kind of a thing, but it was not exactly the standalone data protection law we're talking today. It was basically to safeguard the data, and mostly the data which is given through computers only. So it was basically to safeguard the data and all. And then the story started in 2017. The Supreme Court of India was hearing a case of Puttu Swami. The case was relating to we have an Aadhaar number in India, like we have Aadhaar card, like unique ID. So case was relating to whether the Aadhaar number is something which is, I have a right to, preserve it, I have a right to share it or not, kind of a thing. Someone can force me to share that number, etc., etc. So Supreme Court, while hearing that case, they decided that before we hear the case, actually we should now first hear whether the privacy is a fundamental right in India or not, as per the Constitution of India. So this was the larger bench of Supreme Court, which they talked about it. They heard this case in 2017, and they came out with a decision that yes, privacy is a fundamental right in India. So as per our Constitution, it is very well covered. The privacy of personal privacy is a fundamental right. So that's where we started our data privacy journey. At the same time, Supreme Court also told the government to please make a law on the data privacy, since data privacy is something which is required a legislation now. And that's where it's all started. A committee was set up in India to make the law on the data protection. But unfortunately, it took a lot of time. Time in the sense, a bill came in 2019 first, within 2 years. The bill was sent for deliberation, for discussion to the cabinet, to the public, this thing. And there were a lot of suggestions were made by different parties, different stakeholders. So there's a lot of issues around that. Then there was a lot of amendments. Then another bill came in 2021. Then that bill was withdrawn by the government because there was a lot of expectation, different expectation from the different stakeholders actually. Finally, we came out with another law in 2023, namely Digital Personal Data Protection, DPDP we call it formally, Digital Personal Data Protection, which means it only talks about the digital data, talks about either the data through electronic form or the data in the hard copy which is scanned or made in the digital form, etc. So that's where we started. The law was passed in 2023. Rules were in the process of making. Now we think that everything is done. But then since last 2-3 years, we are in the process of gearing up ourselves to make compliances. And the basic things, the basic functions, or what I would say the principles which this law covers are as under. One is that, of course, the basic law is, of course, you have to take care of the data, you have to protect the data of the person. but it talks about the personal data only as of now. And then there are the person whose data is there is called data principal. We call it data principal. So what are the rights of a data principal under the law? What are the rights we have? Can I ask for deletion of my data, for example? Can I ask for the correction of my data? Can I ask for correction or maybe some other kind of a thing in my data? So one is the right of a data principal. The second is it's applicable on all kind of entities, whether government, non-government, all kind of organizations. So these are called data fiduciaries. The data fiduciary is someone who on whose instruction someone is processing the data. So there are one data fiduciary, the other is data processor. So someone who is processing the data is called data processor under the law. Someone whose instruction you are processing the data is called data fiduciary. And then, so therefore, data fiduciary has a lot of obligation and responsibility on them to safeguard the data, as well as on data processors. Then there are two types of data fiduciaries. One is data fiduciaries, the other is significant data fiduciaries. The significant data fiduciary is yet to be defined, but as of now, it looks like the significant data fiduciary means those who are handling the sensitive data or a large volume of data. So they will be covered as a significant data fiduciary or SDF as we call, and there will be much more compliances on those. So the idea is that all those who are significant data fiduciary in India, they have a lot of obligation, such as they need to appoint a data protection officer, which is not necessary in any other case, but for significant data fiduciary, they need to have a data protection officer. They are subject to an assessment on a periodical basis. They are subject to a third-party audit by, the agencies which will be nominated. So these are the things. And then it also talks about a couple of other things. For example, children data. The children data should be consented by the guidance, by the guardian or the parents. So whenever you have to process a data for a children which is below the 18, you need to take a consent of the parent or the guardian in that way. So all kind of a consent should be very clear, unambiguous consent, and it has to be a very well proper consent. It's not, it's formal consent actually. Then you need to have a consent manager, for example. And there's another opportunity for companies, because consent manager can be a third party or maybe a generally third party who can be appointed as a consent manager in your organization to manage whole consent system and all. Then in terms of compliances, there are a lot of compliances as we have in other countries also. Breach of data and all has to be reported. The penalty size is, it ranges from, if I talk in euros, 5 million to 25 million euros. So if there is a complete breach, it will be around 250 crores in Indian rupees, which are around 25 million euros. So it all depends on the kind of, the kind of breach you have. So overall idea is that, the rules are still in the process of, they have been made now, but they have not been notified. So as of now, everything is in the process of gearing up. We are all getting us ready for this compliances. It has been implemented in phase manner. So few things have already been started being complied with, for example, banks, etc. and all. And the last thing I would like to state is that, in terms of transfer of data, the government has kept a lot of things with itself as of now, it seems. In case you have to transfer the data outside the India, you can only transfer to the countries which have been notified by the government, which is not yet clear which countries you can do that, what are the process and not. But you can only transfer the data to the countries which have been notified. And then the government has kept a lot of things to itself, like, a lot of exemptions. Which is a good idea. I don't know whether it's a good idea or bad idea, but government can actually exempt a lot of industry to comply with that for security purpose, any other reason, medical reason, some other reason, employer-employee relationship, for example. You are giving your data, so you need not to give a consent to your employer because your data can be used anywhere. It may be required for some medical emergency also. So there are a couple of things. The government has power to give a lot of exemptions to the compliance of this law. But as of now, things are still not in a very clear state, because till we have the entire rules with us and we have a framework with us which is to be implemented, I think for the next year onwards it will be complete in full way. So that's all from the India perspective of data protection law. Thank you very much for your precious time.
Hi, good morning / good afternoon everyone. My name is Mr. Wakas Farid. I'm from the UK. Predominantly I'm a litigation lawyer. This is my second time with the World Litigation Forum. It was previously known as, now commonly known as the World Lawyers Forum. And there was an interesting part at the very beginning what Azam actually pointed out. It seems like he's got a bit of a fear factor for us litigators. So I hope, and I hope sincerely, that's not why he actually changed the name overall to the World Lawyers Forum, although it is inclusive. But in the famous words of Liam Neeson, we do have a special set of skills. We will find you. I will leave it as that. But for now, we're on side. So Azam, you've got nothing to worry about. So who are Conquest Law Solicitors? We're based in the UK. It's been about 5 years now since we've been in practice. We opened up, we went for it, we never looked back. The last time I was here, I did outline to the respected colleagues who were present that we had recently opened up in London. That's been very successful since then. We're about 1.5 years in since then. And as a firm, we are developing, hopefully by next year, and hopefully if I do appear with the World Lawyers Forum again, I would be pleased to inform you that we will at that point open up our third office. So we are developing, we are moving, and without further ado, I'll introduce myself to this topic. By no means, I'm not like my respected fellow panelists. These are all experts of their respected areas. For me, data protection is something new, but it was a challenge, and I thought it's something that I should come here today and outline to you from the UK perspective what I came to know and what I'm come here to educate you somewhat. Before I get into my presentation, there are very competent individuals in here. The fact that you made it all the way out here to Amsterdam is actually, it shows how, you know, how much in love with law we are, where we can come to the forums like this and share it with each other. So rather than going straight into it, I want each one of us here to give each other a clap, and a clap for everyone in the room, please. So what's the key legislation governing the data protection in the UK? These are, well, there were formerly two. As of this year, there's a third one. So it's the UK GDPR, which contained the core principles. As well as that, there's the Data Protection Act 2018, which supplements the UK GDPR with provisions for special categories of data, law enforcement processing, and national security. And as of this year, the introduction of Data Use and Access Act 2025, which gave some further amendments to the UK GDPR and DPA 2018. Predominantly, the future of data protection laws in the UK have been shaped by the interplay of UK legislation law as well as evolving case law. Key trends include the emphasis on accountability, governance, and compliance, as well as the increasing role of data protection officers and data protection impact assessments. The introduction of Data Use and Access Act 2025 marks a significant development, amending key aspects of the UK GDPR, DPA 2018, and related regulations. This legislation introduces changes to data subject access requests, enforcement mechanisms, and law enforcement processing, with further provisions to be implemented through statutory instruments. These amendments reflect the UK's effort to adapt its data protection framework to emerging technological needs while maintaining alignment with international standards. The UK GDPR on Data Protection Act 2018 established a principle-based framework for data protection with 7 core principles: lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, as well as accountability. These principles are fundamental to compliance and are enforced by the Information Commissioner's Office, otherwise known as the ICO. Organizations must demonstrate adherence to these principles, particularly through measures such as data protection impact assessments and the appointment of data protection officers where required. Data protection officers play a critical role in advising organizations on their data protection obligations, monitoring compliance, and acting as a point of contact for the ICO's office. These principles ensure that data is handled lawfully, transparently, and securely, with accountability being a cornerstone of compliance. So what compliance challenges do the UK face in relation to data protection? Well, they face challenges in adapting to technological advancements, as has been discussed earlier here today in relation to AI and online profiling, while navigating the complexities of cross-border data transfers post-Brexit. Compliance with resource-intensive obligations like data protection by design adds to these challenges. Compliance strategies include implementing robust governance frameworks, conducting regular risk assessments, and maintaining appropriate policy documentation, especially when processing special categories of personal data. The Data Protection Act 2018 mandates that such documentation outlines the conditions relied upon, retention policies, and measures to ensure compliance with data protection principles. Organizations are encouraged to publish these policies to enhance transparency. To address these challenges, organizations in the UK are adopting robust compliance strategies. These include, as alluded to earlier, data protection officers, conducting data protection impact assessments, and leveraging privacy-enhancing technologies. Transparent policy documentation and proactive engagement with the ICO are also critical. There are various case laws within the UK, and these are just a couple of examples where the illustration of the application of data protection laws are applicable. And some of these examples have been listed here, but to briefly outline the case of Dello, where the court clarified the supervisory role of the ICO under UK GDPR, emphasising its discretion in investigating complaints and ensuring compliance. Furthermore, the case of Bridges and South Wales Police examined the use of facial recognition by law enforcement, highlighted the need for compliance with data protection principles, including proportionality and necessity. Similarly, in the case of NT1 and NT2 Google, the court addressed the right to be forgotten, highlighting its roots in both data protection laws and earlier domestic legislation such as the Rehabilitation of Offenders Act 1974. And finally, the case of Riddle v. Hall and Google, which established that claims for distress alone, without any financial loss, are actionable under data protection laws. So what's the role of the ICO? The UK faces challenges in balancing data protection with technological innovation, particularly in areas like artificial intelligence and online profiling. The ICO's guidance and enforcement actions will likely play a pivotal role in shaping compliance strategies and addressing emerging risks. The ICO is central to the UK data protection regime. It enforces compliance, investigates complaints, and provides guidance to help organizations navigate emerging risks and technologies. So with respect to the future outlook of data protection, the UK's data protection regime must navigate the complexities of international data transfers post-Brexit, ensuring alignment with global standards while maintaining its domestic framework. The future of data protection in the UK will require balancing innovation with privacy. An organisation must adapt to technological advancements while ensuring compliance with evolving laws and maintain alignment with global standards. To summarise my presentation here today, the UK data protection landscape is ever evolving to address new challenges while maintaining a strong emphasis on accountability, governance and compliance. Organisations must adopt robust compliance strategies, engage with the ICO and remain vigilant to navigate the challenges and opportunities ahead to ensure compliance with the UK GDPR, data protection and the recent Data Use and Access Act 2025. Unless I can assist you any further, that's the end of my representation. Thank you very much for attentively listening here this morning. I know it can get quite lengthy, but I want to thank the World Lawyers Forum once again for inviting me over, and I hopefully that's provided you with some sort of a brief insight into the future of data protection law concerning the UK. Thank you very much.
It's so nice to listen about the landscape of regulation and the challenges of each jurisdiction in terms of data protection. I can say that in Brazil, our challenge nowadays is how to guarantee that the countries that we are doing transmission of data has the same level of protection than our country, because it's a requirement in Brazil. How to do it? How to not stop the deal because of it? How to include some clauses that can substitute this level of protection of the law of the country in terms of contract. This is our most important challenge in Brazil nowadays. I would like to initiate our debate now, and I have some questions specific for each panelist, and I would like to invite you to do it sit if you prefer. I think that it could be made more dynamic. I would like to start with a question for Nico. What practical steps should companies operating in or with Indonesia take now to stay compliant and competitive given the latest updates and challenges in your jurisdiction?
Thank you. Okay, so there are two sides of this. The Indonesian companies or companies that operate in Indonesia. The first thing is to appoint a DPO to the extent possible. That would be the first step. Obviously, appoint a DPO that is experienced and certified. Now with the DPO, hopefully that person will be able to advise the company how to manage data processing in a compliant manner, to perform all its obligations and reporting requirements with government authorities and the like. So appointing the DPO will be the vital important step. Now in terms of being the counterparty to a transaction where an Indonesian party is on the other side of you, number one, you raised a very good point about the challenges. How do we make sure that the counterparty comes from a jurisdiction that has a level of legal protection that is equivalent to what you have in your respective country? Now, I can't say Indonesia is there yet. So there, you need perhaps to consider that. But we're on our way. Also, the other thing is, if you have challenges, Indonesia is a country where there are examples where G2G, to the extent that you have the capability to involve the government, is a country where that may be effective. So if you have any issues, for instance, maybe engage with anyone in Indonesia, maybe engage with your government, and then sort of to have that channel, G2G channel, to resolve any issues that may arise coming from your Indonesian counterparty. The other thing is, if you have a commercial dealing, it will be good to have an arbitration clause as opposed to just a court clause. Indonesia is a signatory to the New York Convention, so if you have international arbitration awards, it will be enforceable in Indonesia. Whereas otherwise, if you have a court clause, clause submitting jurisdiction to courts, any foreign court judgment will not be enforceable in Indonesia. So if you have a favorable court judgment in wherever you are, if you want to pursue your Indonesian counterparty, you would have to relitigate that in Indonesia, I'm afraid. And litigating in Indonesian courts is not fun. Maybe fun for me, but not for you, I would imagine. So, and obviously we are a very highly regulated country, and so there are various other obligations and requirements that all companies must comply with, and it would be good to engage, as I said, a DPO and maybe a legal advisor to advise you of those requirements, so that you don't avoid. And so you could avoid the traps that our government would like to put to people. And so jokes aside, but that is an important step, I think. Yeah. Thank you.
Well, actually, you did pique my interest in your presentation when you referred to basically private party litigation regarding data protection. We've had the legal opportunity here in the Netherlands, in the EU, for quite a while now, but at least in the Netherlands, we have not seen it take off. I think that part of the challenge is that monetary rewards for intangible damage under Dutch law are very limited. But I'm curious, what is it that's being litigated at an intra-party level in Indonesia?
Well, there are two things. One is a criminal proceeding. So there's a data breach involving customer data that is managed by a bank. We're sort of, our client is the consultant that advises the bank on where the issue first arose. And so the police got into it because it became politicized, because it involves a local government bank. And so the police was involved, and now the police has launched criminal investigation. We're representing the consultant that advised the client, the bank, which ultimately, where the data was sourced from, sort of became breached and became unlawfully disclosed to third parties. So you have the government aspect of it, right? When you come across, when you have the government or the law enforcement on the other side. Another component to that is the interstate party dispute, where you have potentially two commercial parties that engage in an agreement, and you have in a potential dispute under that agreement. Now, in our particular case, the findings is not necessarily favorable to the client that engaged our client. You see, and so the question is whether or not we've our client, that is the consultant of the bank, managed the findings or the discovery process in a way that yielded the result, that eventually established the bank's wrongdoing, whether or not that was proper and whether or not that was accurate. So you had that that issue, whether or not the findings of our client was actually, can be accountable, whether it was right. And that is also, so that is a potential litigation or arbitration that we're potentially looking into. And there's also another component to this is, claims from customers who owns the data subjects, right? And Indonesia, frankly, is not an area, well, it has rised up in recent months. I think there are around 3 cases that went to that had a criminal verdict. in respect of those cases. But before the data protection law, there was only just one case that came from a customer who filed a lawsuit against a bank for a data breach. And the court, which is a local court in Indonesia, eventually found that the bank was in breach of the was liable for the data breach, and the court only the damages that the court awarded was not even $20,000. So it's a very, very low amount, and how the court came to that quantum of damages eventually in its decision, I think it was just sort of, I think this is a fair amount. So it's not necessarily based on sort of an tangible or intangible loss, but it was really based on fairness. But that was pre the Indonesian 2020-22 PDP law. It'll be interesting to see how after the PDP law, how the courts would how they would assess quantum of damages against aggrieved parties. But the cases that have gone for criminal conviction is. The fines that have been imposed by the courts between 1 to 4 billion rupiah, which is roughly 100 to 400,000 United States dollars. So is that the sort of the quantum that we'd be expecting in a civil case? I don't know, but it's interesting to see how it develops.
Thanks.
Absolutely.
Great. The litigation is always a difficulty. In Brazil, it's the same. We have good position in the law in terms of fines, for example, because the range of penalties are mentioned in the law. And this is good because it's not leave for the judgment, only for the judgment. The minimum is mentioned in the law. This is good. The next question is for Pavle. How should businesses reflect these evolving European court decisions in their IT contracts and data transfer agreements to remain compliant and mitigate risks?
Great question. And if we had a day or two for me to present, I could give you a complete overview. But initially, and most importantly, is from our profession, we need to become more technologically aware, more technologically capable, because a lot of the solutions that we need to implement contractually rely on describing what will need to be done technically. We can no longer get away with including a boilerplate language on the fact that the supplier will comply with all applicable regulations. Rather, we need to define the manner in which the supplier needs to do that, or when representing a supplier, we need to delimit the responsibilities of the supplier vis-a-vis the buyer. So important things to look at are transparency, traceability. So can you illustrate where information is being stored? Can you prove that information is not being exported without the knowledge of the customer? Going on, you need to look very well at your data privacy by design, data protection by design. How do you make sure that you are processing the absolute minimum of information required to get the job done? And also the question then is, how do you apply pseudonymization or anonymization technologies into your work? And how do you make sure that in that manner you limit the exposure of data and personal data to any wrongdoing? So basically, I'd say we need to try to transcend the legal requirements, work together with our partners, and come up with solutions where the legal solution helps the technological solution come up with the right way to protect interests.
I really love your team health data, and I would like to suggest next year a panel about blockchain in order to protect healthy health data, because there's a lot of initiatives in blockchain in order to protect health data, because it seems a very good technology in order to follow this subject. Well, my next question is for you. Just a minute here. I don't want to put my glasses, then I need to have a little fight here. Well, healthcare and research depend heavily on cross-border data sharing, but at the same time face increasing regulatory scrutiny. What are the main legal challenges organizations encounter today, and how might the new AI legislation influence this landscape?
Thank you so much. Yes, for now, a few points I would like to raise here. The GDPR, to start with, was meant to have harmonization among Europe. So we have 6 legal grounds for processing health data, and of course you need an exemption for the actual prohibition to process health data. So we thought in 2016, we thought, oh, the world is going to be wonderful now with regard to sharing health data, because each and every institution and country only has 6 legal grounds. Unfortunately, that has not occurred. We have a fragmented legal landscape in Europe as we speak, where this country has the consent as a legal ground, the other country has legitimate interest, another country has public interest. So data sharing already within Holland and also beyond in Europe, and you can imagine beyond Europe, is still increasingly difficult. It has become even more difficult in my view. Then, of course, apart from having the GDPR, we have our national health legislation, which still can and does exist on top of the European legislation. So, as we speak right now, and I will keep it short, as we speak right now, we have a fragmented landscape with regard to data sharing for healthcare and health research. Hopefully, is now what we said, hopefully the European Health Data Space is going to solve everything once again. So in 2016 we thought that the GDPR would solve everything, and we knew after the European Health Data Space that hopefully is going to solve everything, because then, with regard to data sharing for research purposes, it will be done on what we call the opt-out. So you agree unless you do not agree. Will it solve all the issues? I do hope so, even though right now in Holland, as we speak, there is already a dichotomy where some scholars say, oh, it still has to be consent in Holland, and others say, oh, it can be with the opt-out. So we will have to wait and see. That's one challenge. A second challenge, what we see are the contracts in place, and that follows from my first assumption that still the contracts have become, troublesome in agreeing upon the contracts. How can we solve these issues? I do believe in blockchain technology. I do believe in AI, where the sender still has the keys to the information, and the recipient in no way, with all technical or organizational measures, will be able to retrieve the individual behind it. For me, that would be a wonderful solution indeed. Give it back to you, because I know we're in a tight schedule, and I can imagine that all of you would like to have lunch.
Sameet, the next question is for you. What initiatives from the Indian government should international companies pay close attention to, and how might these developments reshape cross-border compliance strategies?
Do you really want me to answer? But there was a 5-minute slip was given to you, and people are waiting for their lunch. No, I think Indian government is doing a lot of initiative as of now. The idea is that this particular regime is on the Indian residents actually. Unlike GDPR, where it applies to the citizens, it's basically for the residents. So someone who is not from India but is staying in India the data is also protected. It has to be protected, personal data. And the international companies, so far as any company which is profiling the data of any Indian resident, either for the purpose of any marketing or for any other reason, or for health purposes, or except some exceptions are there for the health purposes. So anyone who is profiling data of any Indian residents or marketing or selling something, that data is also to be protected and under compliance regime here. So I think from international perspective, I don't know how it actually gets the final data rules and all still to be implemented. But the government is very careful and very cautious about that because we are a hub of outsourcing also for many Western countries. So we need to be very careful in terms of securing data and the cross-border transfer of data, so that all the regimes or the compliance is there.
Did you pay attention? Great. Wakas, in your view, what are the main challenges that businesses in UK are currently facing in data protection compliance, and how do the challenges inform the global debate on future data protection frameworks?
I'll keep it rather short and simple. I think the biggest problem that not only the UK faces but around the world is the artificial intelligence. Although back in 2016, the case of Piro talked about how the AI could provide greater consistency and be less expensive than manual alternatives. As opposed to that, there are cases such as Getty and the Stability AI, which talks about the underscoring of potential AI to be a foil litigation, as it raises intricate legal questions about the use and protection of digital content. So I think as time moves on, data protection will be ever evolving. I think the biggest challenges they face is from artificial intelligence, and that's something that obviously practitioners such as ourselves should keep in mind, and experts such as yourself on data protection, you should endeavour to obviously apply in your respective fields.
I agree. The point is that technology is always faster than the law. By the time we keep on something, we keep on doing some compliance and all, already there are systems in place. So I think particularly artificial intelligence and all. So I agree with my co-panelists that lawyers have to be very, very tech-enabled now and using artificial intelligence. Somebody was asking what is the risk of threat of artificial intelligence to the lawyers. I would say that if you are not using artificial intelligence, then definitely there is a threat. But otherwise, you need to be, of course.
I just want to finish on this comment. I was here last year and I did talk about artificial intelligence. And the point I raised about artificial intelligence, whilst it is the unprecedented phenomena that is going to be applicable, I'll just leave this point to yourself. Now, I'm sure I can speak on behalf of everyone in the room. We've lived and breathed law. That's what we've done. And effectively, what AI is now is, you don't have to read the whole case anymore, just read the summary. Now, who would you be more comfortable with in representing you? Would it be an individual who's a computerized individual which could have its limitations, or would you have someone who lives, breathes law, and then they can use their experiences and their wider technological assistance to assist you? I know myself, I wouldn't want a computer over me if I'm on a hospital bed. I want a human who's got that empathetic touch, who will know how to apply the relevant systems and assist me, right? This is what it comes down to. But I'll leave that for another day. I believe the topic of AI is going to be tomorrow. I'm sure the respected experts in the room will provide a comprehensive outlook to that. But thank you anyway.
But you need to be careful with one thing. The people have started using, in litigation and all, started using ChatGPT for making petitions and making applications, and even making judgments with the judges. Recently, the Singapore arbitration, I think there were 2 or 3 judgments were dismissed only because they seem to be the judgments of their earlier judgments copied. So that's another way, because you need to be careful and you need to really see whether I've seen, you must be knowing that, there was a case law which was mentioned in a court, or actually there was no case law as such, the ChatGPT came out with that case law. So the lawyer was penalized heavily for that. So it has to be used with sensitivity.
Yeah, exactly. I'm sorry, subject is so nice, but our time is over. We have time for questions. We have time for questions of the. Okay.
I'd firstly like to thank the panel for all of their insights into the future of data protection laws. By way of introduction, my name is Celine. I'm a student and degree apprentice at the Degree Apprentice. I'm here on behalf of Voice, a youth think tank. My question is regarding the topic of data sovereignty and other jurisdictions developing data protection. So you mentioned earlier the case of Trends, specifically how he took Facebook to court over processing his personal data, and as a result of that, there has been more introduction to more complex data transferring outside of the UK. So linking to the recent news that Mark Zuckerberg in the White House has shown his intention to invest $600 billion by 2028 into the US data centers. I'm interested to see what you think of this, is my first question. And then my second question is, how would you be able to remain vigilant on data protective rights for, say, EU, India, Indonesian citizens that are using, social media like Facebook, Instagram, Snapchat? Thank you.
Pass the hot mic, why don't you? First of all, addressing, I'm not sure whether we can talk data centralization or decentralization, because when I look around internationally, we are seeing an amazing boom in data center expansion. So the fact that, with all due respect, when you look at information coming out of the White House, I'm old and ugly enough to remember what it was like to function behind the Iron Curtain, what it was like to read the Pravda. So I know my agitprop, basically your better quality propaganda. So what comes through the Trumpian White House, please take with a large grain of salt. But that does not change the fact that the amount of data centers that are being built is expanding exponentially, which, especially for the young among us, should make us extremely concerned about environmental aspects of that. But the other important element is data centralization, how much data gets sucked into centralized systems. And Meta is one player, but it's a player that many individuals have a choice over, whether you use WhatsApp, Facebook, Instagram, you choose. You have other players like a Palantir, who you have no say about. You have corporations delivering data solutions that are outside of the democratic control and rather are controlling the democratic process. So if there's a point of concern, you want to look at that. So at the end of the day, we're looking at a very diverse, very complex data transfer environment that we're living in. It's being slightly better regulated, but on the other hand, we are looking at a geopolitical landscape where our attempts at better regulation are getting railroaded by brute force, because when you look at issues raised by the Trump administration, such as the extremely unfair levying of value-added tax on digital payments. And if we're talking about taxation issues internationally, I think that these are the questions that we're going to be debating, namely, how much national sovereignty do we retain in determining tax policy? Or do we accept that national governments need to bow to the fact that there's an alpha dog out there who determines which national industries they want to protect, and basically blackmails governments into not taxing them locally. So these are the challenges. It's a wonderful time to be alive, because these are things we've not had to deal with before, and that leaves us in the fun situation of trying to come up with new solutions and new workarounds to protect basic individual rights. So for the young among us, I envy you on the challenges that you'll be facing 20, 30 years down the line.
I suppose just a couple of things just on that. I think I touched the fact that data center investments are increasing not decreasing. So I think we should expect a rise in data center investments going forward, and it's not going to go down anytime soon. The second thing is just on that, interestingly enough, Indonesia and the US signed as part of the tariff agreement or tariff negotiation an agreement for data sharing between the two countries. And it became a really hot topic in Indonesia because then it touched upon personal data privacy, safety, and data commercialization of personal data and the like. So there is an increasing awareness of our citizens and people in general about these topics. And what I would say to that is, I think there's a couple of ways to consider how you would adapt to this. Number one is just increase your awareness and you're just being more informative and educated about the various rights that you have and the obligations of the data processor or the data controller that manages your data. What should you be expecting and what are the requirements that protect your data? Like for instance, in Indonesia, consent is an explicit requirement. Consent has to be expressed. It cannot be implicit. It has to be, yes, I agree for this particular purpose. The second thing is, this is to protect Indonesian citizens, is that all the consent forms must be written in the Indonesian language. So Indonesian language is actually a very fundamental requirement in Indonesia. In fact, a recent, even in your commercial dealings, there's a recent case where an arbitration award was set aside because the underlying agreement was not executed in the Indonesian language. So just being aware of these various requirements and educate yourselves about these requirements could help you, be more vigilant and protect your rights, against data breaches and whatnot. And just on the sort of your lifestyle aspect of it, I think number one, I don't know, what sort of how people deal with social media. I don't have social media. So I'm very less likely to have my data breach because I don't have social media. Maybe that's one thing to consider. The other thing is don't bring your mistress to a Coldplay concert.
Thank you both.
He has a question.
Just a comment. Data center is the most recent trend topic in Brazil. We have this last weekend a new and the most important TV program about the construction of a lot of data centers in Brazil, in Minas Gerais, in the countryside.
Thank you very much for touching this very sensitive topic. Actually, I have a question from the perspective of a company that receives a huge volume of personal data. And for example, if you proceed with signing an agreement, what will lawyers do? We say, for example, it's made in two samples, one for the customer and one for the company, supposedly. And it goes without saying that the company's copy is the company's property. And it contains both customer data and data about the company itself. So at some point, when the client decides to exercise his or her right of being forgotten, what the company might do is, for example, assess the necessity of personal data in the future. And if, for example, we go out of the civil legislation, but we go to the criminal legislation, which says that, for example, any claim towards the company could be brought within a period of 20 years, you think that probably the agreement that was signed 10 years ago might be needed for 10 years longer. So what do you do actually? Do you erase the data from the company's system, IT system, but you still keep the documents that do contain personal data about the customer? Or what do? Do you hide from the system and just ensure that the data is not anyhow processed except from being maintained in the system, just because it appears in the documents that you have as your property as well?
As regards health data of the patients, and that of course is a specific example, if a patient would like to exercise his or her rights, we will honor that. But there is a huge but here. We will ask him or her over and over and over again, This is truly what you want. You want your data to be erased from our systems, from other electronic health records, forever and ever and ever, and we will not be able to retrieve your disease, the treatment you had, anything and everything. If that individual, the patient, still says, yes, I want everything to be erased, we will honor that request.
But the response to that is that what if, for example, after exercising the right, the client comes up and says that you have previously altered the personal data that concerned the customer, so what happened? You transferred data that was not really authentic or trustworthy. What would happen then? I mean, how would you prove that the data, for example, at some point, some portion of the data was provided by the client himself or herself? That's a huge dilemma, because if it concerns the duly protection of the company's rights and interests, at some point you don't know how you proceed. I agree with eliminating the use of the data, but afterwards, if at some point you have to position yourself as an entity who has acted accurately and compliant with the applicable legislation, that's going to be harsh.
I think that you need to take into account that whenever you're drafting data processing terms, one of the most important clauses you include is that you reserve the right to maintain the data in order to comply with your legal obligations. And in that situation, when a data subject wishes to exercise their right to be forgotten, it's not an absolute right. And you see it also from the Google litigation. It's a question of balancing interests. And the right to be forgotten, to my knowledge, has never been accepted as existing in a situation where it would affect the data controller or the data processor in their possibility to comply with their legal obligations. So, very simply, if somebody walks up to your client and says, you have files on me where my person contain my personal data, including contracts, I want you to remove my name from there. If you want to get creative, you can say, okay, what I'll do for you, my friend, I'll pseudonymize your contract, so I'll enter it into register. I'll remove your name from contract data.
I cannot do that. I cannot do that.
Well, you could. I mean, parties can always agree to amend a contract. I mean, that's getting creative, but very simply, I think most efficiently, you'd say, no, I can't. And then the data subject can't exercise their right to be forgotten.
In Brazil, it's the same. We can keep some data after the requirement of the user. In some cases, for example, for tax purposes, by 5 years, for legal obligation for 10 years, then we inform the client, okay, we will remove your data for our files, blah, 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 but we need to keep some information in order to attend these specific requirements.
Mm-hmm. But do you mention accurately all the requirements?
Yes, we mention for the user why and which data we will keep to obey these requirements of the law. Thank you very much. It was a pleasure to share this panel with you guys. Thank you very much.
Thank you so much for our panel for the future of data.